Hello and welcome to Student Data Privacy for Educational Technology Companies. My name is Holly Hawkins and I'm the Chief Safety and Privacy Officer for iKeepSafe, and I'll be conducting this training webinar for you today. This training is designed to introduce you to the Federal Educational Rights and Privacy Act, otherwise known as FERPA. Our training focuses on demonstrating the importance of protecting student privacy while advancing learning, highlighting the key provisions of the Federal Educational Rights and Privacy Act, and communicating the privacy and security responsibilities for companies offering educational technology to schools. Educational technology is playing a significant role within the classroom, transforming the way educators teach and students learn. With the increasing use of technology comes the increasing concern for student data privacy. What is being collected? How is it being used? Who is it shared with? And how is it protected? Are questions that both educators and parents are asking. Let's take a few minutes to get a privacy overview as it relates to K through 12 education.
Digital technology is designed to give each of us information we are looking for, or information we find interesting. As we use this technology, it keeps track of our individual interests, choices, and activities in order to get better at providing information. When students are using digital technology, their activity is also individually tracked and used by multiple sources to create a more personalized web experience. This means content, ads, and visual images are selected and used based on the individual's digital behavior and profile. So what a student does shapes her web experience. What does that mean? Based on a student's digital behavior, others are making choices about what they are experiencing, like colors, sounds, and content. What a student sees or is exposed to on digital platforms is going to be different than what a teacher or another student experiences. In other words, it creates a different experience for each user. And what we experience online impacts our entire life. When students engage in the digital world, others are able to use their behaviors and activities to make decisions for them and about them. Does he live in an affluent area? Would she be a good candidate for college? Would they repay their loans? How do digital platforms access and use information? From the internet provider and cloud storage facility to the hardware designer, everyone involved in constructing digital platforms may access information and activity about the user. They track and collect this data and use it for various purposes, including selling it to others. So, when students use social media, games, email, or services like online shopping, their digital footprints are followed and used by multiple sources, which impact their specific web experiences and their lives. How do digital platforms successfully deal with security and privacy? Companies in the digital industry must comply with certain laws and standards. For example, health records must be private, so companies set up systems to ensure security and restrict access. The financial and healthcare industries have well-established privacy and security practices. They use technological tools and employee training to be successful. Other sectors like education are working together to implement similar practices. What is the importance of privacy practices with student information? Several state and federal laws require privacy protection for students and children. Some laws, like COPPA, deal with third-party collection and use of personal information from children under 13. Other laws, like FERPA, protect student education records. Many states have new laws more specifically restricting how types of student information can be used or shared. What are the risks of failing to protect student information? Failing to protect student information creates risk for schools and companies. Some are financial, like legal fines or lawsuits. Other risks include loss of public trust or damage to reputations. In some states, individual educators can be held responsible for a breach in digital privacy. How do educators develop best practices for protecting student information? Some medical and financial industries have established best practices for protecting personal information in response to legal requirements and customer expectations. Leaders in K-12 education are working to develop and normalize similar best practices for protecting student information and ensuring secure digital environments. Do parents have a role when it comes to working with children and students? Yes, parents are an important part of the process and have a critical role in ensuring student privacy. Parents can teach and model responsible digital behavior, support the school in safe digital practices, and prepare their child to live successfully and safely in a digital culture. In addition, legally, parent consent is required to share certain types of information. These are reasons why parents must be included in discussions about privacy practices. By working together, educators, industry, and parents can create digital practices, tools, and training needed to protect student privacy while using student information in appropriate ways to advance learning.
So you see the concern about using student data privacy to track and build profiles of students for purposes not authorized by the school. As indicated in the video, the education sector, following the financial and health sectors, is becoming much more focused on student data privacy with federal laws such as COPPA and FERPA, as well as an increasing number of state laws. Failing to protect student information creates risk for both the schools and educational technology companies. So our focus in this training is to understand FERPA and your obligations related to FERPA when offering educational technology. Let's start by looking at the definition of FERPA. FERPA is a federal law that protects the personally identifiable information, or PII, in students' education records. The law applies to all educational agencies and institutions that receive funds under an applicable program of the U.S. Department of Education. Under FERPA, an educational agency or institution is defined as any school, district, or state education agency that 1. Receives federal funding, and 2. Either provides educational services or directs public elementary, secondary, or post-secondary institutions. And for the purposes of this training, I'm going to simply use the term schools when referring to agencies and institutions. Now, the funding can be provided directly to the school, like a grant, for example, or it can be provided indirectly to students attending a school. The student then uses the funds to pay the school for educational purposes, like the Pell Grant program and the Guaranteed Student Loan program. If the school violates FERPA, they risk losing their funding. This is one of the reasons they're paying such close attention to educational technology companies. In looking at the definition of FERPA, it's important to recognize what constitutes an educational record. Education records are records that are directly related to a student and that are maintained by a school or a party acting for or on behalf of the school. I've underlined a party acting for or on behalf of the school because this is where educational technology companies fall. You, as an ed tech company, are acting on behalf of the school. And we're going to take a closer look at this further into the webinar. Take a look at some of the examples of educational records that I've listed on the screen. Examples range from transcripts to class lists to student financial information. I also want to point out at this point in time that educational records include personally identifiable information. What is PII? FERPA has a broad definition of personally identifiable information. It includes both direct identifiers and indirect identifiers. Direct identifiers include information that relates specifically to an individual, like the student's name, student's address, social security number. Indirect identifiers include information that can be combined with other information to identify specific individuals. It can be a combination of the student's date of birth, place of birth, mother's maiden name, race, gender, and even weight. Then there's the other category. Take a moment to read what I've noted under other. It's information that would allow a reasonable person in the school community who does not have personal knowledge of the relevant circumstances to identify the student with reasonable certainty. This is broad, and again, we're looking at a very broad definition of PII. Within PII, there's information that can be defined as directory information. This is information contained in the education records of a student that would not generally be considered harmful or an invasion of privacy if disclosed. Directory information generally includes things like name, address, telephone listing, email address, photograph, grade level, honors, and awards. And I could go on. When you think about directory information, think about the information that could be included in a yearbook, a school program, or a write-up in the local newspaper about a sports activity or other school event. Also, I use the term generally when speaking about directory information because it is left up to the school to determine what is identified as directory information. It is completely voluntary, and they don't have to include any information as directory information if they choose not to. Up to this point, we've focused on the information that FERPA protects. We've defined student educational records, the PII within the student educational records, and a subset of PII known as directory information. Now we're going to discuss how FERPA protects the data by 1, providing rights to the parents and eligible students, and 2, placing obligations on the school with respect to student education records. FERPA gives parents and eligible students certain rights with respect to the student education records. And just to note, an eligible student is defined as a student who is 18 years of age or older. So these rights, they are 1, the right to inspect and review the student's education records within 45 days after requesting access. 2, the right to request changes be made to the student's education records if the parent or eligible student believes they're inaccurate, misleading, or otherwise in violation of the student's privacy rights under FERPA. 3, the right to provide written consent before the school discloses PII from the student's education records, except to the extent that FERPA authorizes disclosure without consent, and we will be talking about that very shortly. 4, the right to file a complaint with the U.S. Department of Education concerning alleged failures by the school to comply with the requirements of FERPA. Moving on to school obligations. FERPA places certain obligations on the school. First, FERPA requires schools to obtain parental consent prior to disclosing PII from students' education records. The consent must be written and must be signed and dated by the parent. It must also specify the records to be disclosed, the purpose of the disclosure, and the parties to whom it's disclosed. Next, FERPA requires the schools to notify parents and eligible students of their rights, the rights that we just reviewed on the prior slide, to inspect and review, to seek amendment, to consent to the disclosure of PII, and to file complaints with the DOE. Schools must inform parents and eligible students annually of their rights and must deliver the annual notice in a manner that is reasonably likely to ensure that parents or eligible students are aware of these rights. Typically, notice comes home at the start of the school year, among other forms parents must sign. Sometimes it's included in the parent-student handbook. And then lastly, schools must maintain records of requests for access to the disclosure of personal identifiable information. Schools must keep a record of each request for and each disclosure of PII that is contained in the student's education records. There are limited exceptions in which FERPA allows for a school to disclose PII from an education record of a student without consent from the parent or eligible student. Here are a few of the exceptions that most closely relate to educational technology companies. Schools can disclose de-identified information. That is information from which all PII has been removed and/or a reasonable determination has been made that a student's identity is not personally identifiable. Schools can disclose student directory information. Remember, this is information schools have deemed as student directory information. There's no standard other than to say it would not generally be considered harmful or an invasion of privacy if disclosed. And schools can disclose to a school official. FERPA allows school officials, including teachers within a school, to obtain access to PII in education records if the school has determined that they have a legitimate educational interest in the information. Let's take a look at the directory and school official exceptions. First, the directory information exception. We already know that directory information is the information contained in the education records of a student that would not generally be considered harmful or an invasion of privacy if disclosed. This information may be disclosed to third parties without parental consent, provided the schools have 1. Define the directory information they intend to disclose. 2. Given public notice of the types of information which it has designated as directory information. And 3. Provided parents or eligible students with the right to restrict the disclosure, including a time period in which a parent or eligible student has to notify the school in writing that they don't want any or all of the information designated as directory information. When first learning of directory information, it seemed to be an easy way to share PII with third parties, including edtech vendors. However, this exception is not as easy as it first appeared. Schools determine what they consider to be directory information, so it's going to vary. Additionally, parents and eligible students have the right to opt out of disclosing directory information, so their information can't be shared with you. There are a number of parents and eligible students who do opt out, and schools may find this exception cumbersome to manage, not to mention some children will not be able to participate in the learning experience. Schools are more likely to use the school official exception. A contractor, consultant, volunteer, or other party to whom a school has outsourced services or functions may be considered a school official with legitimate educational interests. EdTech vendors can be considered a school official. EdTech offers learning, communication, and record-keeping platforms, just to name a few, and these are legitimate educational interests. Schools may disclose PII from students' education records to a provider as long as the provider, and the provider meaning you, performs an institutional service or function for which the school or district would otherwise use its own employees, has been determined to meet the criteria set forth in the school's annual notification of FERPA rights for being a school official with legitimate educational interests, is under the direct control of the school with regard to use and maintenance of education records, and uses education records only for authorized purposes and may not redisclose PII to other parties, unless the provider has specific authorization from the school to do so, or is otherwise permitted by FERPA, such as in the case of an emergency. When PII from education records is disclosed to you, FERPA still governs its use, and the school is responsible for its protection. We're going to take a look at 4 responsibilities of EdTech vendors who are acting on behalf of the school. Those are minimization of data collection, adherence to school control of PII, transparency of data usage, and data security and confidentiality. As a general rule, don't collect more information than is necessary to provide your product or service. Take a close look at the information you intend to collect in connection with what you're providing in order to ensure that you're only collecting information that's necessary. The data should be adequate and relevant in relation to the purpose for which it is collected. Remember, the school is providing access to you to provide a product or service on their behalf. As a provider, you're under the direct control of the school with regard to the use and maintenance of PII from educational records, if the disclosure was made under FERPA school official exception. As such, agreements should prohibit PII from education records from being used for other purposes or redisclosed without the school or district's permission. Education records must be used as agreed upon in the contract with the school and for the benefit of the school. Using student PII, for example, to serve targeted advertising is not to the benefit of the school. Education records must not be redisclosed without the school's permission. If you're sharing information with third parties to help deliver your product or service, let the school know. The presence of third-party service providers, such as analytic companies, ad networks, or others, must be disclosed to the school. Schools must be provided with information about what data third parties will have access to and why, as well as assurances that third parties will not be allowed to use PII for purposes not authorized by the school. This is usually shared in the contract with the school and should be posted in your privacy policy as well. You must access the privacy and security policies and practices of third-party service providers. Take a look at them to ensure that they are capable of complying with your guidelines and your practices. Schools must be notified in advance of any changes to the terms of the contract or agreement, including the governing privacy policy. Changing the terms of a contract or agreement without notice makes it difficult for a school to just demonstrate direct control. Upon request, provide parents with access to their child's education records, or eligible student if that's the case. FERPA guarantees parents and eligible students the right to access their information, including those maintained by providers on behalf of the school. And this has to be done within 45 days of the request. As a best practice, access to their child's education records should be seamless, with providers giving the required records to the school, who can confirm the parent or eligible student's identity and provide them with access to the records. In some instances, parents and eligible students have direct access through your product functionality as well. Develop and make available clearly written policies explaining what data the product may collect, how the data is used, how it is stored, and who it is shared with, as well as what happens when it's no longer needed. These policies should also reflect general security practices that are in place to protect the data, and must accurately reflect actual data handling practices, and be easy for schools to access. You must take appropriate steps to ensure the data shared with any third party adheres to the same policies. And again, notify the school in advance of any changes to these policies. It's important that you protect the data through appropriate physical, technical, and administrative safeguards. Take steps to secure the data. Access to student data must be role-based, limited to only those employees who need access to perform job responsibilities. Make certain that these employees with access have undergone criminal background checks. Conduct annual privacy and security training for employees who have access to student data. And this holds true for any contractor who may have access to student data as well. As a best practice, create and maintain a security policy manual that provides detail on data management, employee data access, and compliance procedures. Secure the data in transit and at rest using technology that meets industry standards. Next, be prepared in case of a data breach. Make certain you have policies and procedures in place in the event of a data breach, understanding that state laws do vary in regard to data breach and notification. EdTech vendors and schools should be clear on these policies and procedures for responding to a data breach should include when and how notification of the breach will be issued, and by whom. Lastly, be prepared to destroy all personally identifiable data obtained under the agreement with the school when it's no longer needed. That is at the termination or end of a contract. Or you can transfer the data back to the school or designee of the school if that's what the school has indicated. It's best to have a data destruction plan in place that includes a timeline as well as a method of destroying the data. In summary, FERPA is a federal law that protects student data by providing rights to the parent or eligible student and placing obligations on the school with regard to use and disclosure. There are exceptions under which a school can share the data. If the school shares student data with you, as an EdTech vendor, you also have obligations. You need to minimize collection, use the data under the control of the school, be transparent regarding its use, and take measures to secure the data. This brings us to the end of our training. Thank you for joining the webinar and for your interest in student data privacy and responsible practices. Please send any questions related to this FERPA training to training@ikeepsafe.org. Thank you.